There's a moment in certain cases where everything quietly goes wrong, not in the courtroom, not in the verdict, much earlier than that. It's the moment when suspicion stops being a question and starts becoming an answer. And the problem is, you can't see that happening while you're inside it. Because from the outside, everything looks normal. Experts are consulted, evidence is collected and reviewed, and a coherent narrative or legal theory of the case forms. But once the narrative takes hold, something changes. The system stops asking what happened and starts defending the answer it's already chosen. In Australia, a woman lost 20 years of her life to it, because the narrative became the lens and not the evidence. And once that happens, everything that follows is shaped by a story someone else has already decided to tell. By that stage, doubt doesn't disappear, it gets absorbed into the narrative. The story starts to feel coherent and it has a ring of truthfulness about it, even though there is none. This isn't about one case. It's about a failure pattern, an uncomfortable question. What if the same pattern isn't just a relic of the past? What if it's happening again, right now, in front of our very eyes? Miscarriages of justice don't begin with bad evidence. They begin with a story that forms faster than the evidence can. Wrongful convictions are sustained by systems that prioritise legal certainty over doubt. This series traces how the pattern consumed two very different lives: Kathleen Folbigg in Australia and Lucy Letby in the UK. Different names, different countries and different decades, but the same broken system. Kathleen Folbigg is an Australian woman who spent 20 years in prison after being wrongfully convicted in 2003 of the deaths of her 4 children, Caleb, Patrick, Sarah and Laura. It was alleged at the time that the children died between 1989 and 1990. She was found guilty of manslaughter, grievous bodily harm and 3 counts of murder. And she received a 40-year sentence, which was later reduced to 30. And at the time, the case looked overwhelming. It was one of those kind of cases where guilt feels obvious. And that's what makes what happened next so uncomfortable, because something happened that the justice system really does. The inquiry came, the pardon followed, and then, for the first time in 20 years, someone used the word innocent. After 2 decades behind bars, Kathleen was pardoned in 2023, when new scientific evidence showed that the children likely died of natural causes. The science had finally caught up. 2 of the children carried a rare genetic mutation, and it was known to trigger sudden fatal heart arrhythmias without warning. The other had their own medical vulnerabilities. And for the first time, each death had a credible, natural explanation. This is not a new pattern. The new scientific evidence created enough reasonable doubt to change the course of the case, ultimately leading to Kathleen Folbigg's pardon. She was once labelled Australia's worst serial killer. Kathleen always maintained her innocence, insisting that each child died naturally. What happened to her wasn't an isolated mistake. It was the start of a pattern we are now seeing again and again. Because when the same failure happens twice, it stops being a coincidence. And if Kathleen's case was just one case, it certainly would be a tragedy. But patterns don't stop on their own. They repeat until someone recognises them. And when that pattern re-emerged, it collided with a case carrying the harshest penalties a criminal justice system can impose. And I'm talking about the Lucy Letby case. She received 14 whole-of-life orders, the most severe punishment English law can deliver. In the entire history of the UK criminal justice system, fewer than 80 people have ever received one. Lucy Letby received 14. one nurse, one hospital, no DNA evidence, no weapon, no witnessed act, and a 5-year window of so-called wrongdoing, and evidence that turned out to be far from trustworthy. And of course, that same familiar pattern. Back again, only this time with momentum we have not seen before. Lucy Letby was convicted in 2023 of murdering 7 infants and attempting to murder 6 more at the Counties of Chester Hospital in the UK. She has maintained her innocence from the beginning and is currently challenging her conviction through the Criminal Cases Review Commission. But here's what this case has that almost no other conviction in modern legal history has. In 2024, an international panel of 14 independent specialists, neonatologists, paediatrician experts, forensic scientists reviewed the same medical evidence the jury saw. And what they concluded raises a question the system has not yet answered. Their overall finding was that they had found no medical or scientific evidence to support the mechanism of harm alleged at the trial. The core mechanisms of harm used to explain the deaths at trial was not supported by the evidence. A number of the babies had naturally medically supported explanations for their deaths, such as being born prematurely or having a serious infection at the time of birth. Some presented with complications that are already known as fatal risk factors. And then the assumption, Lucy Letby's presence equalled responsibility, that the nurse who was there must be the cause. If these conclusions are right, the question isn't whether mistakes were made, it's how a case of this magnitude ever reached a verdict to begin with, and why at every decision point no one stopped it. When you're looking at these cases side by side, a pattern begins to surface, one that hides in plain sight. Both Kathleen Folbigg and Lucy Letby occupied caregiving roles, positions we expect to be defined by compassion and steadiness, yet the moment suspicion entered the room, their ordinary human behaviours were reinterpreted as signs of imagined danger. When a caregiver becomes a suspect, the story automatically changes and the evidence is forced to follow. And in both cases, institutions were under immense pressure to find a single, coherent explanation for the unexplained deaths, a mother at the centre of multiple losses, and a nurse present during a cluster of collapses. And the need for certainty pushed each system towards the simplest narrative. Because once an institution demands an answer, it really waits for the right one. And then there is the very flawed statistical reasoning in both cases. It stepped in to fill the gaps in the evidence. The debunked rarity assumption in the Folbigg case and the presence-based clustering in Letby's both relied on the idea that probability could substitute for proof. And when numbers replace nuance, probability starts masquerading as proof. And finally, in both cases, the absence of direct evidence didn't slow the narrative, it accelerated it. No mechanism of harm, no forensics, no eyewitnesses, just interpretations layered on interpretations, until the story felt like the only conclusion left was that they were guilty. That's where the silences in the evidence gets filled in with whatever the narrative demands. The same failure pattern that imprisoned Kathleen Folbigg for 20 years appears to be operating in the Lucy Letby case. What you've just heard is only the beginning, because the pattern doesn't end with 2 women. It doesn't end with 2 trials. It runs much deeper, into the institutions that should have caught this, into the experts who should have asked harder questions, into a justice system that confused presence with proof and called it certainty. Over the next 4 episodes, we'll follow this pattern to its source. In the next episode, we'll go back to the moment before the arrest, before the charges, before the courtroom, to a system under pressure that stops scrutinising itself and started looking for someone to blame. We'll examine how Dr. Evans' history shaped the narrative that followed, how the Criminal Prosecution Service position shifted, and how tunnel vision didn't arrive all at once, but closed in slowly, one decision at a time. And then in episode 3, we expose what happens when a case runs out of evidence and starts running up a story. I'm talking about the coincidence fallacy, or put another way, the quiet return to Meadows' law in modern clothes. Presence mistaken for causation, patterns mistaken for proof, and a legal system that simply shifted its target from mothers to professionals. And then in episode 4, the evidence falls apart. No eyewitnesses, no sustainable mechanism of harm, no forensic proof, no motive that holds up under examination. We trace how inference began stacking on inference, and how an undisclosed General Medical Council investigation in the UK cast a shadow over the very experts the jury trusted the most. And then in episode 5, we arrive at the most uncomfortable question of all. What happens when a woman's grief becomes evidence? When her private words, written for no one else, are handed to a jury and called a confession. From the I am evil note to the criminalisation of distress, we examine how both prosecutions turned humanity into suspicion, and what that tells us about the stories we tell and when the facts fall silent. But before any of that, there is one question that ties every piece of the evidence together. One decision made early before the trial, a decision that shaped everything that followed. In the next episode, we'll find out what that decision was and why no one stopped it. In the end, these cases are not just about two women or 2 decades of legal and medical missteps. They're about the deeper pattern that emerges when systems under pressure reach for legal certainty instead of truth. When institutions close ranks, when inquiries collapse too quickly, when science keeps moving but the law won't pause, the people in the middle become the narrative instead of the evidence. The real question is, how many times has it happened already, and how many of these cases still haven't been questioned? If you've made it this far, you already know there's something wrong in the system. The question is whether anyone with the power will fix it, and whether they're asking the same questions this series raises. Subscribe, share this, because the cases we don't talk about are the ones that stay buried. I'll see you in the next episode.